Parents, teachers, and school administrators in California, this update is for you. AB-985 may be affecting you in a profound way very soon. Remember, this is the bill that has passed the California State Assembly and is on Governor Newsom's desk to sign or veto. It doesn't help anyone, but it sure does put all of California's children at risk. You've heard me get loud about this bill because it's absurd, nonsensical, fills zero need, and makes it so any loose relation to a child, says that person, can assume custody of said child, and there's little to no verification process required. This legislation puts kids at risk and all California schools, public and private, and even daycares and homeschool co-ops in a horrible position with really no court or legal backup. I've got your basics on the latest. Governor Newsom now has until October 12th to sign or veto this outrageous bill. And what happens if he does sign it? Well, against a mountain of public pressure and outcry to veto, lawsuits are likely already brewing. But can they stop this bill? Typically, a lawsuit challenging a new law, rule, or regulation will seek injunctive relief, which would preserve the status quo and stop the new legislation from going into effect while the lawsuit works its way through the courts. Injunctive relief would need to be granted by a court. It's not automatically given just because someone files a lawsuit, and it usually requires a hearing. At that hearing, the party or parties seeking the injunction would have to show, among other things, a likelihood of success on the merit of the lawsuit. So we wait to see what happens there, again, if the bill is signed into law. If it is signed, and while the lawsuits work their way through the court, schools can be smart and prepare by training employees, teachers, and staff on the requirements contained in the bill. For example, staff should be trained on the ways they can legally validate a caregiver authorization affidavit, such as verifying that the person presenting or signing the affidavit is over 18, that the child lives with him or her, and that that person signing is a relative within the 5th degree of kinship as defined within the bill. Remember, the courts won't do that now under this legislation. Schools should also regularly monitor California Department of Education and Attorney General websites for any guidance that may be posted. And while the bill does not offer any formal opt-out procedure for parents, it's clear that if an employee of a school is aware that a pupil's parent or guardian is not available to care for the pupil, the school shall first exhaust any parental instruction relating to the pupil's care in the emergency contact information it has for the pupil to arrange for the pupil's care. Parents, be sure you provide your kids' schools the names and contact information of individuals you want contacted and potentially your child released to in the event of an emergency. Schools can support families by sending regular reminders to parents to make sure that emergency contact information is complete and up to date. And everyone can help by tagging Vice President J.D. Vance to call on him to publicly oppose this bill.